Hello, I'm Christian Gomez for The New American. Former Wisconsin Supreme Court Justice Daniel Kelly is seeking a new term, which will be decided in the spring election next year. Justice Kelly is a constitutional scholar, and we know you'll enjoy this message he gave at a recent event featuring several conservative candidates held at the Freedom Project in Appleton, Wisconsin. Here is Justice Daniel Kelly.
Well, good evening, everyone. It's great to see all of you. You know, it was 2 weeks ago. Good afternoon. Dave, how are you? I just have to say hello. I haven't had a chance to see my friend.
Fellow Irishman.
Indeed true. So it's good.
Good to see you.
It's good to see you all. You know, a couple weeks ago, we celebrated Constitution Day, and I love that day. And I thought perhaps that this evening we could begin by remembering that 235 years ago, Benjamin Franklin walked out of Independence Hall after having signed what would become one of the most famous documents in human history. The Constitutional Convention had just wrapped up its work, and they were preparing to introduce to a waiting and watching country a brand new and novel form of government. And as he left Independence Hall, a woman approached him and said, "Mr. Franklin, what have you given us? A monarchy or a republic?" And with a twinkle in his eye, Mr. Franklin said, "A republic, if you can keep it. If you can keep it. If you can keep it." You see, he was not referring to all of the people that he had just spent all of that time with, hammering out the details of this new form of government. And he wasn't referring to all the people who would hold office under this new form of government. He was looking straight at the woman who asked the question. And by extension, he was referring to all of her fellow Americans. If you can keep it, you won't keep what you don't treasure. And you can't treasure what you don't understand. So I thought perhaps we spend a little bit of time thinking about why it was this was such an impressive and novel and important development in political philosophy in this new Constitution. You see, these provisions that we all know and love, they did not exist at the time that Benjamin Franklin was answering the woman's question. That didn't come for 4 more years. And yet the people who wrote the Constitution understood themselves to have done something profoundly important and innovative. They believed that that document as it stood would protect our rights. So let's take a look at what that was. What was it about that document, unadorned by the Bill of Rights, that they believed would be capable of governing a country and at the same time protecting our rights? Well, the concept was one that they borrowed from Montesquieu, the idea of the separation of powers, that you don't want all governmental power resting in the hands of one person or one group of people. It gets separated out amongst the 3 branches. And we're all aware of those, right? The legislative, executive, and the judicial. And we say that they are co-equal. And indeed, in one sense, that is true. They are equal in dignity. And that means that to the extent that the Constitution vests a certain type of authority in that branch, the other branches don't get to touch it, right? Same is true for each of the branches. They are co-equal in dignity. But the framers did not understand them to be co-equal in importance or in function. The way I like to look at this is to look at this in terms of a timeline. There's a very strong correlation, as it turns out, between each of the branches of government and a spot on the timeline. So we have legislative, executive, and judicial, and on the timeline we have future present, and past. So let's start with what the framers believed to be the most important branch of government, the legislature. Now, they've got a really difficult job. Isn't that right?
It's very difficult.
That's a tough job. We don't know what the future is going to be. And we all know that when we take a step, there are unintended consequences to those steps, and they have to be really careful about each of those steps that they take to minimize those unintended consequences. And that's one of the reasons that that is the most populous branch of government. We have 99 assemblymen, 33 senators, taken from all over the state, and our expectation is that they will bring all of their wisdom and their experience and their intelligence and their insights and their specialized areas of knowledge, and they will combine together to figure out what those wise laws ought to be. And so they look to the future, and they figure out how we can live together in peace and prosperity with those laws that they work on. So that's the legislature. The executive takes for himself the present. Now, the role of the executive and the judicial branches are both derivative of what the legislature does. And that's one of the reasons why the legislature is the most important. They pipe the tune to which the other two branches dance. So the executive's role is to take what the legislature did and apply that today. Carry out those laws. In the words of the Constitution, to see that the law is faithfully executed. And so that person's role is to carry that law into effect today and in every tomorrow as it becomes today. And that's the executive's role. So we've got the legislature, they got the future. We have the executive, that has the present. Got one spot left on the timeline. What is it? It's the past. Yeah, and it's the judiciary gets the past. Now, here's how that works. So the judiciary works in a museum of sorts. It deals with things that have already occurred. They're already in the past, long before they come to the courts for their consideration. Someone's breached a contract. Someone's gone beyond what the law prescribes. Someone's committed a crime. It's all stuff that has happened in the past. And so their role, when they put on that black robe and walk into that museum, is to find the relevant artifacts that are in the museum. They come in two types. One, well, they're the facts of the case, right? Figure out what actually occurred that has brought this dispute to the court. So they look for those facts. The second type of artifact is the law. You see, because the law keeps changing, because the legislature, well, they keep doing their job. And so the law changes. Every time they pass a bill and the governor signs it, the law changes. But the work of the court is to apply the law as it existed at the time that those facts occurred. And that's exceedingly important, because that is the promise of the rule of law. You see, what we expect as Wisconsinites and as Americans is that we know in advance what the law requires of us, right? And then we can choose to conform our behavior to what the law requires. And in doing so, we can live together in peace and in prosperity and outside of jail. Now, what happens if that jurist goes into the museum, but he brings stuff with him, right? And so he brings his own conception of what the law ought to be. He brings in his own predilections and his desires and his dislikes. And he says, I don't like some of these laws and I like others. I think this law is okay, but it could be better. I don't think this law is efficacious or efficient, so I'm going to change them. I'm going to update the Constitution. Perhaps you've heard of the phrase, living Constitution, right? Living Constitution is when a jurist looks at the constitutional command and says, I don't really like what it says. And I've got a better way of organizing society. And so they go in and they adjudicate the case before them, not according to the law as it existed then, but according to the law as they wish it to be instead. And so what's that look like? So now, the person in the case, they say, well, okay, this is what the law was when I made my decisions on how to act, and I relied on the law being that. But Judge, you're telling me now that there's a different standard. You're telling me that you don't like that law, so you're going to do something else. You're telling me that you think the Constitution is out of date, but I was relying on the Constitution when I made my decisions. And that is the destruction of the rule of law. So it is exceedingly important that the jurist simply decide the case and stop. Now here's the thing. Not everybody agrees. Not everybody agrees. You say you won't keep what you don't treasure, and you can't treasure what you don't understand. I was reading an article just the other day in The Hill, and it was reporting on a poll. The question they were polling was this: should the president be able to dismiss jurists whose opinions he believes to be against the national interest? 35% of the respondents said yes. 22% said, I don't know. So 57%, and I'm told, am I coming up against my time?
You are.
All right, let's wrap this up. I'm told that when a poll is taken, that's supposed to be representative of us as a whole, not just the people polled. And so we hear from this poll that 57% of the people either think that we can dispense with the separation of powers that I just explained to you, or don't care. Or don't care. You won't keep what you don't treasure, and you can't treasure what you don't understand. I'm sure that if you ask that 57%, do you support dismissing the Constitution? I'm sure they'd say no. I'm sure they'd say, I love the Constitution, but they don't understand it. And the very thing that lies at the heart of the Constitution that the framers believed was the novelty that they introduced to a waiting and watching country that would protect their rights, the 57% of people said, either I don't want it or I don't really care if it goes away. So every year we celebrate Constitution Day so that we can understand. And having understood, we can treasure. And having treasured, we can keep. Thank you all this evening very much for an opportunity to spend some time with you. God bless every one of you.